In any civil lawsuit, you've got at least two sides with two completely different stories. So how does the legal system actually figure out what happened? Well, it's not guesswork. It's all about a powerful, structured toolkit designed to uncover the truth one piece at a time. Today, we're going to unlock that toolkit and explore the absolutely crucial process of examinations in civil procedure, from the very beginning right up to the courtroom itself.
First, we'll set the stage for this whole evidence-gathering game. Then, we'll dive deep into the pre-trial discovery phase. That's where lawyers use most of these tools. After that, we'll see how testimony can be saved before a trial even starts, what actually happens in the courtroom, and finally, we'll wrap up with the universal rules and, yeah, the pretty serious consequences if you don't follow them.
At its core, every single lawsuit is about a conflict of facts. One person swears the light was red, the other insists it was green. The system needs a reliable, fair, and transparent way to test these stories and build a record of what actually went down. This isn't some chaotic free-for-all. It's a highly regulated game with very specific rules of engagement.
Right, this is the million-dollar question, isn't it? When you watch a sharp lawyer in a movie, they seem to know exactly what to ask and what the answers will be. Well, spoiler alert. It's not psychic ability. It's the result of months, sometimes even years of hard work using a powerful set of pretrial procedures called examinations.
And that brings us to the discovery phase. The vast majority of a lawsuit actually happens long before anyone steps foot in a courtroom. This part is all about forcing each side to lay their cards on the table, their evidence, their witnesses, the good, the bad, and the ugly of their case. The number one goal? No surprises at trial.
The absolute cornerstone of this phase is the examination for discovery, which is all laid out in Rule 31. This is a formal process where lawyers get to question the other party and their key witnesses. And here's the kicker. It's all done under oath. That means the answers carry the same legal weight as testimony in court and can totally be used later at trial.
So who can be put in the hot seat? Well, Rule 31.03 makes it really clear it's not just the main person whose name is on the lawsuit. If you're suing a big company, you can question an officer or an employee. If it's a partnership, a bankrupt individual, or an assignee, those folks can be examined too. The whole point is to make sure you can question the person who actually has the information you need.
But this questioning doesn't go on forever. To keep things efficient and, frankly, to prevent harassment, Rule 31.05.1 puts a strict time limit on it. A party gets a grand total of 7 hours for all their oral examinations for discovery. That's it. This forces lawyers to be incredibly focused and prepared because they only have time to ask the most important questions.
So what's fair game within those 7 hours? Well, Rule 31.06 says the scope is incredibly broad. You can ask pretty much any proper question that's relevant to the case. You can ask for the names of other potential witnesses, you can find out what the other side's expert is going to say, and you can even ask about any insurance policies that might be in play. It's all designed to get every fact out in the open.
Now, lawyers also have a choice of format. You've got the live, face-to-face oral examination under Rule 31, which is great for asking dynamic follow-up questions on the spot. But there's another option under Rule 35, serving a list of written questions. The other side gets 15 days to provide answers in a sworn affidavit. This can be a really smart move for highly technical questions where you want a precise, carefully thought-out answer, not something off the cuff.
Okay, but what about cases where a person's health is the main issue, like in a personal injury claim? Rule 33 gives lawyers a very specific tool for this situation. If a party's physical or mental condition is a central part of the case, the court can actually order them to have an independent medical examination. This is how the system makes sure that claims about injuries or disabilities can be verified by an impartial expert.
And this isn't something you can just demand. The process is super structured. According to Rule 33, you have to file a formal motion with the court. Then a judge decides if it's really necessary and issues an official order. After the exam happens, the doctor writes up a report, and, this is key, Rule 33.06 says that report has to be shared with everyone involved in the case. Total transparency.
So the discovery phase is all about finding out what witnesses know. But what if you have a key witness and there's a real risk they won't be around to testify when the trial finally happens, maybe months or years down the road? Well, the rules have a solution for that too.
This is where Rule 36 comes into play. It lets a party, as long as they get the court's permission, basically conduct a mini-trial examination of a witness way in advance. Their sworn testimony is recorded and preserved, creating an official record that can be presented as evidence at the actual trial if that witness can't be there. It's like a vital insurance policy for crucial testimony.
So when would a judge agree to do this? Rule 36.01 lays out the key factors they look at. Is the witness very old or seriously ill? Do they live in another country, making it super expensive and difficult to bring them to trial? The court weighs all these practical things to decide if it's truly necessary to lock in their testimony early.
All right, after all the pretrial discovery and preserving evidence, we finally get to the main event, the trial. This is where all that information gets put to the ultimate test in front of a judge. Rule 53 sets the standard here. Witnesses testify live, in person, in the courtroom. The process is probably familiar if you've ever watched a legal drama. The lawyer who called the witness asks questions first. That's direct examination. Then, the opposing lawyer gets to challenge their story. That's cross-examination. And finally, the first lawyer can ask some follow-up questions in re-examination.
But cross-examination isn't a license to just bully someone on the stand. As this quote from Rule 53.01 makes crystal clear, the judge is the referee. They have the power and the duty to control the questioning, to shut down irrelevant or nasty questions, and to protect witnesses from being harassed. Their job is to make sure the focus stays on finding the facts.
So far, we've looked at all these different types of examinations. Now let's zoom out and cover the nuts and bolts, the procedures that apply to all of them, and more importantly, the serious consequences for anyone who decides not to play by the rules.
Rule 34 is basically the master guide for how any oral examination has to be run. It spells out that the exam usually has to happen where the person lives. It requires that every single person take an oath or affirmation. It makes sure interpreters are there if needed. And critically, it mandates that the whole thing be recorded so an official transcript can be created.
And what happens if you just ignore these rules? The consequences laid out in Rules 34 and 33 are severe. For example, if you just don't show up for your examination, a court can throw out your entire case or strike out your whole defense. If you refuse to answer a proper question, you can be ordered to come back and do it again on your own dime. Believe me, these rules have serious teeth.
So there you have it. We've toured the entire examination toolkit, a highly structured, rule-bound system designed to get from conflicting stories to a set of established facts. It's built to ensure fairness and prevent surprises. But that leaves us with one final thought. Does this intricate process always lead to the truth? Or can it sometimes become more of a battle of procedure, where the winner isn't the side with the facts, but the one who just knows how to play the game better? Something to think about.